All right. So for those of you guys who've been following along, thanks for the support. For those of you guys who haven't, I'm currently going through a massive custody battle. This is part of my explanation as to what's been going on and how the laws apply, since I keep getting asked and since trolls keep coming up. This is to also address some of them. One of the things I keep getting mentioned is, oh, it's not against your constitutional rights. Well, Ninth Circuit Court website here. I am within the Ninth Circuit. Washington State falls within the Ninth Circuit. Civil jury instructions. Section 9, Civil Rights Action under 42 U.S.C. 1983. Scroll down. 9.32, Particular Rights, 14th Amendment, Due Process, Interference with Parent-Child Relationship. Deliberate Indifference Standard. Deliberate indifference standard applies in situations where the officers who caused the harm to the parent or child acted or failed to act in a situation when actual deliberation is practical. When officials have time to make unhurried judgments and extended opportunities to do better, but unreasonably allow harm to occur, then their protracted failure even to care can shock the conscience, thus giving rise to a substantive due process claim. Custodial interference in the first degree. We have currently a parenting plan issued January 25th, 2024. That still has yet to this day been followed by the mother of my child. She has held him for a protracted period against the parenting plan, which, as you see here, says residential provision order. Under the court case State versus Velas, this is case law, a parenting plan is considered such an order. Under paragraph 3, a parent or person keeping a minor child away from the other parent with intent to deprive access permanently or for a protracted period when no lawful court order exists is still guilty of custodial interference in the first degree, making it a Class C felony. Did you follow me to Robbie's? Because if you did, I'm not going to be happy about it. Let me restate it. You can see him tomorrow before I leave for work, but that's it until we get stuff settled in court. Intent to deprive access for a protracted period. Keeping a minor child from the other parent without a lawful court order. At that point, there was no form of restraining order, DV order, residential provision order, anti-harassment order. There was 0 orders between us at this point. She kept him from me for over a month and a half, and then following a few months later, an additional 7 months. That is a protracted period. That is clearly a Class C felony, intent to withhold. Officers knew about this, and they currently know about the parenting plan. My ex is aware of this, and she currently knows about the parenting plan. 9A 80010. A public servant is guilty of official misconduct if, with intent to obtain a benefit or deprive another person of a lawful right or privilege, he or she intentionally refrains from performing a duty imposed upon him or her by law, making it a gross misdemeanor. That goes in conjunction with 42-20-100. Whenever any duty is enjoined by law upon any public officer or person holding any public trust or employment, their willful neglect to perform such a duty, except where otherwise specifically provided for, shall be a misdemeanor. Section 4.34.020. I suffer from autism spectrum disorder. I am Tier 2, high functioning, formerly known as Asperger's syndrome. as many of you guys are aware. Paragraph 2. Abuse means the intentional, willful, or reckless action or inaction that inflicts injury, unreasonable confinement, intimidation, or punishment on a vulnerable adult. In instances of abuse where a vulnerable adult who is unable to express or demonstrate physical harm, pain, mental anguish, the abuse is presumed to cause physical harm, pain, or mental anguish. Abuse includes sexual abuse, mental abuse, physical abuse, and personal exploitation of a vulnerable adult. My ex had full knowledge and awareness that I had autism. I told her from the very first get-go. Mental abuse is the intentional, willful, or reckless verbal or nonverbal action that threatens, humiliates, harasses, coerces, intimidates, isolates, unreasonably confines, or punishes a vulnerable adult. Mental abuse may include ridiculing, yelling, or swearing. Personal exploitation means the act of forcing, compelling, or exerting undue influence over a vulnerable adult, causing the vulnerable adult to act in a way that is inconsistent with relevant past behavior. Manipulation. I mean, threatening to already take my son? I didn't want to reject you? So right there, she clearly admits to lying to me for the entire course of our relationship, knowing full well I had autism, knowing full well that I would not have gotten together with her and I would not have had a child with her if she really actually told me that from the very beginning. I am reactive. I reciprocate. It's just how I am. Threatening to take me to court. Trying to straight up go for my disability income. Asking a what if. Admitting to it. And she keeps my son for me and stuff like that. And then look at this. She comes back. Oh, I love you. Sending me pictures. Telling me about the guy she's getting with is gay. But yeah, all of a sudden it's on everybody else. It's on Kyle. It's on her mom. She's so excited to get back with me. The moment this man put hands on her and attempt suicide. So again, right there. And then if you scroll down, okay, look at this. Hey. Mandated reporter includes law enforcement officers. Hey, guess what? Neglect. A pattern of conduct or inaction by a person or entity with a duty of care that fails to provide the goods and services that maintain the physical or mental health of a vulnerable adult, or that fails to avoid or prevent physical or mental harm or pain to a vulnerable adult. An act or omission by a person or entity with a duty of care that demonstrates a serious disregard of consequences of such a magnitude as to constitute a clear and present danger to the vulnerable adult's health, welfare, or safety, but blah, blah, blah. Okay? Oh, I should probably show this too. Under paragraph 21, vulnerable adult includes a person who, C, has a developmental disability as defined under this sub-RCW, and under paragraph 6, developmental disability includes autism. Also keep in mind, intellect does not matter. The disability itself does. You could be very retentive like me and still need just as much as support as somebody who's more lower on the spectrum. Our state recognizes that part at least. 10.31.100, paragraph 2. A police officer shall arrest and take into custody pending release on bail, PR, Court order, a person without warrant when the officer has probable cause to believe that, under A here, an order has been issued under which the person has knowledge under 2644063 or Chapter 9A40. Again, going back to 9A40, that covers the custodial interference, which includes, like I pointed out earlier, keeping a child against a court order with residential provisions, aka a parenting plan, and keeping a child without a valid court order giving legal reason to do so. To this day, my ex still has not been charged. And if you go to kidnapping in the first degree, to inflict extreme mental distress on him, her, or a third person, to interfere with the performance of governmental function. As of today, my ex has moved. The PD have no idea where she's at. The GAL, guardian ad litem, have no idea where she's at. I have no idea where she's at. The courts have no idea where she's at. Therefore, none of us have any clue where my son is at. On January 25th, 2024, the day that the parenting plan was signed in, she was told she must give notice to both the court and myself if she moves and when she moves. She still has not. 6 weeks ago, as of Monday next week, we had court. She was told to serve me within that time frame. We still have not received anything. I have not been served by her. It is very clear she is attempting to bypass and interfere with the performance of governmental function. And because of the fact that she has therefore committed a felony through custodial interference and has moved, felony or flight thereafter, any felony or flight thereafter. Custodial interference in the first degree is a Class C felony. Moving without notice or court order, flight thereafter. Sorry about the fire truck in the background. Anywho, point being, it is very, very clear at this point that the officer has violated my 14th Amendment and that they have no plan to actually enforce the law. It is very clear they have committed failure of duty. So, yeah. Anywho, that's it.